trial, I think we had $40,000 or $50,000 worth of expenses. The fee agreement will spell out who's responsible for that and how it's going to get paid. Generally, if the lawyer fronts it, he'll get that paid back to him in addition to his fees.
Now, if I'm an injured person, I'm not sure if I'm going to be able to go back to work, do the same kind of work that I had to before, or was able to before. Wouldn't I feel much more comforted thinking that you'd be willing to take something on contingency, which I assume people want to do, so they don't have to think about out-of-pocketing what could be the flat fee against the retainer, or whatever? Should I be worried about
there are very
contingency?
Few attorneys that would take a personal injury case on a flat fee. I'm not saying that that would never happen, but it's
because it's too long range?
Well,
there's a number of reasons, and one of them is exactly what you just said.
Yeah.
I would be concerned if the attorney said, I'll take it on a flat fee, because what that's telling me is he doesn't think that there's going to be a recovery in your case. Otherwise, he'd want it on a contingency.
Not only that, how do you put a fee on that? How can an attorney at visit number 1 and maybe even visit number 2 at your client make a determination as to how much that flat fee is going to be? Are they saying you're going to get X and I'm going to take a flat fee off that X? You don't know. I mean,
right. Is he estimating how many hours it's going to take for him to do it, or her to do it? Mm-hmm. And if so, if you can estimate those hours, again, most of these fees are contingency. Why aren't I doing a contingency fee agreement in this case?
And then what happens if you lose? So that puts the litigant in a position of saying, well, I still have to pay you if you lose, that's not the nature of how we practice law.
Well, as you said, most people who come to you after being injured are out of work, and their income is therefore disrupted. They don't want to dip into their assets, probably because they need their assets to continue to live on. So that's why people are looking for an attorney who will take it on a contingency.
And also, to have one less thing to worry about if I have to worry about my own healing process, which is, I guess, presumably why I would want a professional to take care of this case so I can focus on the thing which I need to do, namely, how do I get myself well, or think about what I need to do for my family or my next plan or whatever. So we shouldn't be too concerned about, we have to be aware of what your fee structure is, and we should always expect that someone is going to say that right up front in the first meeting about how they're going to be doing it.
Yeah. As a matter of fact, for the individual, they should ask. Again, you have to be your own advocate. What is your fee structure? What's the policy regarding expenses? How will you get your expenses paid? You always want to ask. You absolutely have to have it in writing. You have to have it in writing.
Do people negotiate about that? They negotiate apparently about everything else these days.
Well, I mean, I've heard stories. There are attorneys, and I don't begrudge them for it, but there are some attorneys who will take a case on a 25% contingency.
Yeah, again, if they do that, I'd question it a little bit, because that's not what the standard is, so to speak. But, you know, sometimes if you have a relationship with a lawyer, you can get him to reduce his fees. If I were taking a case that I thought was a very good case, and it was a case that didn't have to go to trial, you know, I would consider doing that. But if I'm going to spend the time, and you want me to spend as much time as I can preparing that case for trial, you don't want me to take a discounted fee and spend less time on it. Exactly.
Exactly, yeah. And there are times, too, when we're trying to settle a case, we have to pay off some of their medical bills. And for instance, some doctors will put liens on files because they want to be assured that they're going to be paid. The insurance companies won't pay them. So in order to settle this case, we need the doctor to reduce his bill. And our procedure is, if a physician's going to reduce their bill, then we'll do the same.
Right.
Because it's not fair if the physician who's treated you is taking less. We should just, more out of courtesy, we would take less.
What happens sometimes is there's a policy limit on the insurance of the person who hit you. And then you may have uninsured motorist coverage, which would then kick in. But between the two, even if it's a large injury and massive medical bills, we want to get as much money into our client's pocket as we can. So we may have to go back to the hospital or the doctor, whoever's owed money, or Blue Cross paid. Sometimes they'll have a lien, Blue Cross, and say, negotiate this down so that we can get a fair settlement and put money into our client's pocket. If that's the case, we would never ask a doctor or a medical provider to reduce their fee unless we reduced ours.
And I think what David's alluding to as far as Blue Cross and liens, people need to know that if you are treating for a personal injury, however it happened, negligence, car accident, slip and fall, your health insurance does have a right to recoup their costs for providing care for you throughout that treatment period. So that means that the lien that David's referring to is they have an automatic right to place a lien on the file. They'll send it to us, they'll send it to the insurance company, and contractually, they have to be reimbursed for the cost for providing your care during the duration of your case until it settles.
What would happen if the person who was injured didn't have their own health insurance?
Then
Well, it depends on the situation.
The neighbor does.
Yeah, well, if they have an insurance policy on their vehicle, they'll have MedPay, which is a policy that provides for medical payments. Usually it's $5,000 or $2,500, depending on what you contracted with the insurance company for, and that will pay regardless of fault. And so you can always tap into that to get your bills paid as the case goes along, if you need to. Again, if someone caused the injury and you're paying it with your policy, MedPay is going to want to get paid back. And so it works very similarly to the medical insurance provider or the doctor who will give you treatment on the expectation that he'll be paid at the end of the case.
in Massachusetts, I think it's also important to point out that they have what's called PIP coverage. It's personal injury protection. What that is the insurance company will pay up to $2,000 of your medical costs. Once you go over that, then your health insurance kicks in, if you have insurance. If you don't have health insurance, then your policy in Massachusetts may pay up to a certain amount on a
Usually
MedPay.
like another $8,000.
Yes, yes. And the other thing, too, before I forget to point it out, is in order to file for a personal injury case in Massachusetts, there is a threshold requirement for damages, so to speak. You have to have $2,000 or more in damages. What do I mean by damages? If your medical bills total $1,000, I can't do anything for you because the law says there's a threshold requirement. You need $2,000 or more in damages or medical fees before you can even file suit.
What about if there were, apart from the physical damages, because I slipped and fell and I've been out of work, I become depressed, there were psychological issues. Is that all part of personal injury as well, or does that?
Sure. Anything
long
that
does that go on?
affects you as a
Okay.
result of someone else's negligence, that causes damage to you, and needing some mental help is certainly a factor. Being out of work, people get depressed sometimes.
Yes,
That's
sure.
absolutely includable. In order to recover, the insurance company is going to require us to prove our case. And in order to prove our case, we need reports from experts. So if it's a mental health issue, we need a report from a psychologist or a psychiatrist who's treating you. So if you have problems and you don't treat for them, we're not going to recover that for you. But if you do go and get help, and we have some proof in writing from an expert, we'll get you a recovery for that.
It certainly seems that there are so many issues tied to personal injury. We haven't even touched on things such as, I don't know, the asbestos issues, or someone did something else at work that wasn't intentional, it was accidental, but I think maybe we need to discuss this a little bit more going forward if we have the
Sure.
time to plan on that for the next week. We have with us once again Jackie Grasso and David Bazar from the law firm Audette, Bazar, Cordeiro Grasso. We say to you, as always, at the end of the show, if you have questions, please do email those questions to dbazar@abcglawfirm.com. And we thank you for tuning in, and we will continue the legal matters discussion next time. So many esoteric questions here.